So the question always comes up, why bother with estate planning when you're young? Speaking of estate planning, right? So estates really consist of everything you own, bank accounts, stocks, bonds, real estate, personal property, all of your assets, all of your financial assets, all of your physical assets, everything that is in your name, so to speak, right, that you own. So the idea is, of course, how are you going to dispose of these when you are gone? Um, when you're no longer around to take care of these things, what is going to happen to them? So it's one of those questions that uncomfortable, but it's essential to kind of get to get these things in order. Okay. So at the root of estate planning again is how your assets are going to be disposed of. How are you going to transfer them on to other people or to donate to to charities, whatever it is, how you're going to dispose of your property upon your death, because you can't take it with you, literally, right? Um, so it has two components. One is to build your estate through savings, investment, insurance, and the second piece is to transfer your estate as you wish at your death. So the first part is the building part, and putting all these things together and making sure that you have everything, your I's dotted, T's crossed. And the other part is, of course, the transfer, getting rid of these things, passing them on to your descendants, right? Or on to whoever you so choose, your beneficiaries. So if you're married, that would include your spouse, children, the estate planning process, of course, uh, other family members or friends, whoever. You make sure that you have all your beneficiaries lined up and the categories, categorically done, going through it piece by piece, step by step. So there are lots of challenges that are out there facing this, but in essence, it comes down to something very simple, and that is that how you want your assets again to be parceled out upon your passing. So there's people, are loath to think about dying, but it's something that's absolutely necessary. Meaning that all of us are facing this, so these are just things to kind of keep in mind. So the idea again is to, just as we were talking about planning for your retirement, plan for that now, not when you're retired. You can't plan when you are no longer with us, right? So make sure you this is why you want to do this when you are in a good frame of mind with some thoughts about how you want things to be taken care of upon your passing again. So on the legal end of it, this is all legal stuff that we're talking about when we're looking at estates and estate planning. Gathering all your necessary documents, birth, marriage certificates, legal name changes if that's applicable, if you're married and if you change your name or for whatever reason, all of your Social Security information, any military records, all of your assets, list of your assets, your insurance policies, your bank accounts, safe deposit records, registration material for all of your property, for your vehicles, if you've got an RV or something like that, and you want to make sure that you have all of your account information available and your beneficiaries lined up so far as your investments are concerned. So a will is what directs that disposition. All right, it's a legal declaration of what your intent is to dispose of your property after your death. So it transfers property again according to those wishes that you express in that will. State law determines it depends upon the state distribution of your estate if you die intestate without a will, meaning that they determine, the court determines how that how your assets will be distributed, right? So this is going through what's the term is called probate. Has to go through probate anyway with the will, but regardless, so the will directs, that directs traffic, so to speak. It expresses your wishes beyond the grave. Um, reviewing your will with someone that you trust, an attorney, etc. Um, and legal costs vary. Typically, again, here is standard will between $300 and $600. It's probably gone up to about $1,000, but it's not terribly expensive. it may or may not be worthwhile for you to go that route. You can do it perfectly valid will on your own if you so choose. But so the probate again is a legal procedure proving a valid or the will itself is valid. So this is the court going through and approving your wishes or following through on that piece of it. So there are different types of will. Simple will leaves everything to your spouse. Traditional marital share leaves half of the adjusted estate to spouse and the other half to whoever you so choose. Exemption will passes everything to your spouse except for an amount equal to the exemption, which passes to a trust. The trust then can provide a lifelong income, if you will. So these are things that are set up for very specific purposes, of course. Stated dollar will designates the amount passed to spouse. Percentages are better due to investment fluctuations. The format's the will, holographic will, where you actually do this by hand. It's handwritten. Some states, I'm not sure which, do not recognize holographic wills. Formal will, usually prepared with an attorney's assistance. Statutory will, type of formal will on pre-printed form. Rigid provisions may not meet current laws and may be invalid if you change provisions. So these are things that are different options out there so far as wills are concerned. So when you're writing, composing your will, the first thing you want to do is, of course, filling out all of your information, of course, that goes with it. And there are definitely examples online, wills that are available that you can fill out and you can go forward with that however you so choose, but making sure again that they are valid within the state in which you reside. It's very important. Selecting the executor, the person who they're the ones that direct traffic, how you want your how you want your will, your wishes to be carried out. They're the ones that do this. They're the ones that are responsible for this. Could be a family member, friend, attorney, account, doesn't matter. If you don't name one, the court will. Keep that in mind. Executors' fees are set by state law, very, very straightforward. The major responsibilities of an executor are to prepare an inventory of assets upon the person's passing. They should have access to all this, collect any money due and pay off any debts, so settle accounts, prepare and file all income taxes and estate tax returns, liquidate and reinvest other assets if necessary to pay claims, distribute assets based on the instructions in the will, make a final accounting to beneficiaries and to the probate court. Settling up, right? Selecting a guardian if you have children. This is you'll have to make sure you put the name of that guardian or trustee, the person who's going to be going to be acting in that person's stead in their interest, right? They assume the responsibility of providing for the child, personal care and managing the estate for them. Trustee will manage property for the benefit of children. It's not for them. It's for the benefit of the children. So be sure that person is willing to raise them and that their philosophy matches yours, because once you're gone, there's nothing you can do about this. So these are very, very important things to consider when we're talking about an executor or a guardian for that matter, right? So wills change, depending upon situations and so on and so forth. These are when you have something complicated and something changes. Maybe your spouse passes away, and so you want to redirect, your will to go to other people, or you fall out of favor with someone, whatever that might be. This is where it probably would be a good idea for you to follow up with an attorney to make the adjustments. It's not that it's that big of a deal, but nonetheless, it's probably important to kind of dotting the I's and crossing T's to do this. So add a codicil if you have only a few changes that are needed. This is a document that explains or adds or deletes provisions within your existing will. Considering just making a new will, it's easier probably to do that, and just to redo the will and change the names or however you want to do it. So living will or advanced directives. Advanced directives include a living will, which of course provides your wishes if you become incapacitated some way, physically or mentally. It's certainly not a substitute for a traditional will, but It's why you're no longer available, no longer able to make decisions for yourself. So there's like the durable power of attorney piece of this, and you can always have some letter of instruction as well for after death, which is pretty much uh, um, it's something. I'm not going to say it's ignored, but it doesn't really hold much water. But again, that durable power of attorney is a very, very important thing for someone that you trust to be able to make decisions for you, medically speaking, right? So there are different iterations of wills, and some of them are kind of rather dubious. It's something that, an ethical will, for example, where it's not a legally binding document, but it kind of expresses your wishes similarly to a social media will, which is interesting. Um, so anyhow, it's something where you'll be posting this out on Instagram, Facebook. I guess not Instagram, doesn't that disappear? But anyway, like Facebook or some other social media your own website. I guess you could do that. It allows you to decide how to handle your online content and identity kind of going forward. Again, rather interesting. So, but the critical piece, the last piece that we're talking about is that durable power of attorney. It's also known as a healthcare proxy, a legal document authorizing someone to act on your behalf in the case that you're unable to do so yourself. You're unconscious, you're incapacitated somehow, some way, and it authorizes someone to act in your best interest, hopefully, right? Letter of last instruction after death wishes, again, not legally enforceable in most states, or in some states at any rate. Provides heirs with important information such as details about your funeral arrangements, names of people to be notified of your death, locations of your bank accounts, etc. All the important information, right?